Hello, everybody, and welcome to this edition of Macro Pro and Friends. I'm joined by Wendy Stevens, my colleague. Wendy, how are you?
Oh, I'm well, Diane. How are you today?
I am fantastic. It's beautiful here in the Pacific Northwest. How is it there in California?
Well, I'm north of San Francisco up in wine country, and the weather is absolutely beautiful. A little smoky from the fires, but it's so beautiful here.
Oh, very nice. So, Wendy, let's talk a little bit about what's happening in the copy and subpoena services, what's happening with the new fee schedule. Can you tell our attendees some of the changes in the fee schedules?
Sure, Diane. The SB 863 copy service fee schedule went into effect. The new fee schedule went into effect on July 15th of this year. And the flat fee went from $180 to $230. That's a $50 increase, which is pretty significant. The EDD code was removed. That means when you need EDD records, you have to pay the regular price. There's also a new electronic storage fee, which is $3. So if you see that on an invoice, that is a legitimate and valid fee. And cancellation, CNR, ANR, affidavits of no records, that fee remains the same. There's now a code for companies on agreed pricing or contracted pricing. So when you get an invoice, that code can just be entered. For those companies that would like a paper set, there's also a code for that, and that's an additional $10. Diane, I know there's a few more things with regulations. Do you want to share a little bit about those?
Yeah, absolutely. So something that's really important to all of our employers out there is that there's now a penalty for not paying an invoice within 30 days. And so it's a 25% automatic penalty. So please make sure that you pay your bills or you object to them. Now, you should know if you object to an invoice, let's say it was billed out at 230 and you thought it should be 180, that $50 will have the 25% penalty applied to it should that be warranted and granted by a judge. So make sure that you're really sure that you're paying it within that time frame. The other thing you should know, and I mentioned being paid by a judge, if there is a dispute, copy services no longer have to have a lien, so they're not paying the lien fees. So it's not like, well, it's $50. They're not going to file a complaint for $50 because it's going to cost them the lien cost, right? So you want to make sure that you pay those bills because they no longer have to go through the lien process, that they can petition for cost. And of course, I'm sure that people will be asking for penalties as well on top of what was not already granted. So make sure you watch that. The fee schedule is in place, it's working. So let's make sure that we just pay attention to what it is. If you have any questions, you can ask Wendy, myself, or any other of the Macro colleagues, and we'll be happy to help you. Now, before we get started, I have a little bit of housekeeping. So today's webinar is worth 1 California CEU credit. You must be logged on to the webinar in order to receive your credit. It's the only way that GoToWebinar can track your time and attendance. So if you're just on the telephone listening in, I'm sorry, you will not receive credit. Secondly, there are handouts that are on the webinar. So make sure you download those so that you can have them for future reference. And if you have any questions at all, Wendy and I are going to be monitoring those, and we'll be asking those to our experts. So make sure to ask those questions if you have any. And then lastly, there will be an encore performance of this on the Macro Pro YouTube page. So please, by all means, feel free to review that on our library and any other program that we've had in the past. Now, Wendy, I know that you have invited our guests, so would you like to introduce them?
Absolutely. Tom, you want to jump on with me?
Hi, Wendy.
Welcome, Tom. So for everybody who's joined today, Tom is one of my favorite speakers. And I'll just give you a little blurb about him. He leads the employer liability practice at RTGR Law, LLP, and is an expert in cases where workplace injuries implicate ADA, FEHA, FMLA, CFRA, Cal OSHA, and other employment issues. Tom is a certified specialist in workers' compensation law, focusing on Labor Code 132A and serious and willful S&W defenses. He holds the highest AV preeminent rating by Martindale-Hubbell and was chairman of the Workers' Compensation Law Advisory Commission, a member of California's Board of Legal Specialization, and vice chair of the State Bar's Workers' Compensation Section Executive Committee. Tom, welcome, and we're so excited to hear about the information you are going to share with us about the CA Candies case.
Thank you so much, Wendy. I appreciate you and Diane's invitation to present this program, and I appreciate everything Macro Pro does to help educate our community and provide continuing education to the people in our colleagues in the community, and for giving us this forum to talk about this really, really important case. There's actually two cases we're going to discuss today. The CA Candy case is probably more familiar to everyone, is the California Court of Appeal case. There's another case, Cusiemba, which involves the same facts, but it's a federal case. It's in front of federal court. And the CA Candy case arrived at one result, and the federal case arrived at another result. And now both cases have been appealed, and both cases are pending in front of the highest courts in California. One is pending, CA Candy case is pending in front of the California Supreme Court, and the Cusiemba case is pending in front of the Ninth Circuit Court of Appeal, which is the highest federal court in California. So one way or the other, maybe both ways, these cases will produce binding legal authority. So this is not a minor issue. This is going to be new law in California. Hopefully, law that is not too detrimental to California employers. There is a risk to California employers the way that the law stands right now, the current CA case. And that's what we're going to talk about, because it seems to undermine the exclusive remedy defense, and the exclusive remedy rule has been shielding employers from civil lawsuit liability for years. First, a little bit of background information. You're going to get copies of these documents, as Wendy said, through the link for the program today. But if you have questions that come up after the program that you don't get to today or don't get answered today, you feel free to email your questions to one of our offices throughout California. You could just email your closest office if you like, and we're happy to respond by email should your questions arise later on. And if you need a copy of the PDF of today's program, we're happy to provide that to you as well. Just email your local office and we'll get back to you. A little disclaimer, this is generalized educational information and is not designed to be a substitute for legal advice on a specific legal matter. If you have a specific legal matter where this is coming up, please consult an attorney. Perhaps somebody at RTGR Law would be happy to help. So a little background about the CA Candy case. Matilda Eck worked for CA Candies at an assembly plant. She contracted COVID-19 allegedly at work and filed a workers' compensation claim and was provided with workers' compensation benefits, as we understand it. She was sent home, of course, to convalesce. And a few days later, her husband and her daughter became ill with COVID. Neither the husband, Mr. Eck, nor the daughter were employed by CA Candy, only Mrs. Eck, only Matilda Eck. But unfortunately, Mr. Eck contracted COVID and passed away because of that illness. That's what's claimed in the lawsuit. Now, Mrs. Eck, acting as the estate of Mr. Eck, who was now deceased, filed a civil wrongful death lawsuit against CA Candy. So in addition to her workers' compensation claim, she now has filed a civil lawsuit against CA Candy on behalf of the late Mr. Eck. So what she claimed in the lawsuit was that The assembly environment at C's Candy required her to work in close proximity to other employees, and that allegedly their claim was that C's was lax in their COVID mitigation protocols, and that this created a foreseeable risk whereby employees would contract the disease at work, go home to convalesce, expose family members to the disease, and then family members would become ill and possibly even die as a result of the COVID infection, which no question Mr. Eck passed away. The only question was his death due to COVID the result of transmission from Mrs. Eck to him? And did C's Candy owe a duty of care to him? And was this claim valid, this lawsuit valid under the exclusive remedy rule? So that's exactly what C's jumped on, is this lawsuit is barred by the exclusive remedy rule. That was their argument. They filed a motion to dismiss the lawsuit saying, hey, Mrs. Eck already filed a workers' compensation claim. She has workers' comp. She's covered under the Workers' Compensation Act. Anything that she is claiming through the estate to have happened as a consequence of her workplace injury is barred under the exclusive remedy rule, and specifically what's called the derivative injury doctrine, which is a sort of a subset of the exclusive remedy rule. And what the derivative injury doctrine says is that the only remedy, or used to say, is that the only remedy for anything that derives from the injury to the employee is the only remedy is within the Workers' Compensation Act. So whatever workers' comp benefits are available to that employee, that is all you get, employee, and that is all you get anyone who claims something derivative of that injury. So the estate of Mr. Eck opposed that motion, and the trial court, again, before the case goes to trial, the trial court is just hearing the motion to dismiss. The trial court looked at this derivative injury doctrine, looked at the years of cases that have been developed on that doctrine, which seemed up until the point of this case to say that the collateral circumstances of an employee's injury are not recoverable. The collateral damage for a workplace injury is not recoverable in civil court. That's why we have a workers' comp court, and that's why we have a separate civil court for non-workers' comp problems. So if C's were to prevail in their motion, had they prevailed in their motion, the plaintiffs would have not been allowed to proceed with the wrongful death lawsuit all the way to trial. And instead, remedies would be limited to what Mrs. Eck got in her workers' comp case. What the trial court did, though, is the trial court came up with something new, or at least to a lot of us, what seems to be new, and denied C's motion to dismiss the case, the lawsuit. The trial court rejected at least my and a lot of other people's common understanding of what qualifies as a derivative injury. The court found that any injury to Mrs. Eck was irrelevant to the late Mr. Eck's claim, because that injury, his injury, is not the injury upon which, her injury is not the injury upon which plaintiffs are suing. That's what the trial court said. The trial court said, it doesn't matter that Mrs. Eck had a workers' comp injury. Mr. Eck has a separate injury that was transmitted to him by an employee who had a workers' comp injury. So that's what the court was looking at. And to get to that result, the court had to find that transmittal of the disease of COVID without illness is possible. And maybe something that happened here. So the court said if the plaintiffs had claimed remedies associated with Mrs. Eck's illness, in other words, that they were saying they were suing for loss of companionship because she was out of commission for a while, recovering from the illness, or loss of income, or some other collateral or circumstantial effect of Mrs. Eck becoming ill, the court said, well, plaintiffs could not sue for that. They couldn't sue for anything that sort of surrounds Mrs. Eck's injury and relates to her. But the trial court assumed that Mrs. Eck did not have to become ill herself in order to pass the disease on to her family. So by making that assumption that it's irrelevant whether Mrs. Eck became sick or not, all that's relevant is that she can carry and transmit COVID-19 to her family, then the family gets to sue, reasoning that Mr. Eck's death was not collateral or derivative of Mrs. Eck becoming ill. It was only derivative of Mrs. Eck's being able to transmit the disease to him. So if some of you are watching this and scratching your head going, wow, that's an awful lot of hair splitting that the court did, you're not off base. So the court was not entirely without legal authority. There's an important case called the Snyder case that the trial court relied on, at least in part, to come up with this interesting result. And the Snyder case is a very unique set of facts that were sort of stretched to apply to the Eck case, in my opinion. The Snyder case was a very unfortunate case. These are all unfortunate cases, by the way. We feel for the families, and the Snyder case is actually a particularly unfortunate set of facts where the employee was working in Marshall's store, and there was a floor cleaning machine that created off-gassing. And this was after store hours, but Ms. Snyder, in that case, as an employee of Marshall's stores, was working after hours, after the store had closed, I guess doing stocking and inventory. And during the closed hours, they were running this floor cleaning machine while she was doing her thing, and maybe other employees were doing their thing. And the floor cleaning machine was off-gassing, so like a toxic off-gas. And at the time, Ms. Snyder was pregnant, and when the baby was born later on, it had fetal injuries that they claimed were the result of Ms. Snyder's exposure to the carbon monoxide in the workplace. So in that Snyder case, the court said that, went into a lot of scientific detail to make it clear that the fetus or child's injury did not depend on the existence of any injury to Ms. Snyder. In other words, the court said, look, it doesn't matter if Snyder, in fact, I don't even know whether Snyder had a workers' comp injury or not. Like, she may have never become ill from her exposure to the carbon monoxide, because as a healthy adult, the exposure level may have been low enough that it didn't affect her. But to the fetus, it did allegedly affect the fetus, and the fetus independently got injured by happening to be on the premises of Marshall's store and being exposed to this carbon monoxide. And the fetus really had no choice to be transported there inside the pregnant mother. So the court in that case, in the Snyder case, said this is an independent injury, that this fetus had an injury that was independent of the any injury that might have happened to the mother. Now, for those of you who are paying attention to this hair splitting that the court did in C's, one big difference between Snyder and C's is that Mr. Eck never set foot on C's Candy premises. The fetus was brought to Marshall's store by Ms. Snyder in the course of her job, but Mr. Eck never set foot on the C's Candy premises. How is C's Candy supposed to control everything that goes on outside of the C's plant? That's a good question. So that's a big distinction in the Snyder between Snyder and Seas that I don't think got a lot of explanation in the court's decision. Another case that the trial court relied on was the Kessner case. And Kessner, I think, is even more far afield from the Seas case, but Kessner is a case where the derivative injury doctrine was not applied, where the exclusive remedy rule did not apply, and I think with good reason. And that in the Kessner case, an employee was working with asbestos fibers, and he came home every day with asbestos fibers on his clothing, allegedly, and maybe even in his hair. There wasn't a lot of, at the time, procedure for, donning and doffing the appropriate wear so that the clothing would be kept at the workplace and not brought home. So what was alleged in the Kessner case was that this, by bringing home these asbestos fibers, and then the fibers would get off the clothes in the wash, just in the laundry basket, and then expose family members, that family members developed asbestos-related disease because of those dangerous fibers being transmitted. So the court used Kessner to say, hey, look, an employee doesn't have to become sick. I don't think Mr. Kessner did. But what he did do is he brought home those dangerous asbestos fibers from where he worked and brought those fibers into the house and then infected family members who did become ill. So that lawsuit was allowed to proceed in Kessner because it was found that those were independent injuries, independent of Mr. Kessner becoming ill. So the trial court relied on both on Kessner and Snyder to find that Mr. Eck sustained his own independent injury as a result of being exposed to a toxin in a related employee's workspace. So in this situation there, the court claimed that COVID-19 is a toxin. So this was appealed by Seas to this decision by the court, allowing this case to go forward, denying Seas' motion to dismiss. That was appealed, again, before the case even goes to trial, by Seas Candy up to the California Court of Appeal. The California Court of Appeal rejected the motion to dismiss, and Seas Candy then petitioned for the California, asked the California Court of Appeal to overturn this. However, the Court of Appeal agreed with the trial court and found that the derivative injury doctrine does not apply to this set of facts. And the Court of Appeal relied heavily on Snyder, just as the trial court did. And in the Court of Appeals decision, they're focusing on the employee being a conduit for the injury to the family members, comparing the facts in Seas to those in the Snyder case, which the court seemed to really rely on. They said that there is little difference conceptually between a mother breathing in a poisonous gas and conveying it to her unborn child, and a wife breathing in viral particles that she then conveys to family members when she gets home. Again, the court didn't spend a lot of time talking about one big difference is that the unborn child was at the Marshall's store in their facility, whereas Mr. Eck never went to the Seas facility. In both this case, in both Seas and Snyder, the court reasoned the employee is merely a conduit of a toxin or pathogen. And according to the court, whether an employee was harmed by exposure or not is irrelevant to the claims of the injured family members. In other words, the fact that Mrs. Eck may or may not have had an illness, which we know she did, is irrelevant. That illness, her particular illness, was irrelevant because she can transmit COVID, the court held, without having become ill in the first place. So it wasn't a derivative injury. They're saying it was an independent injury. So this is an important case as it stands now. This Court of Appeal decision as of right this moment is the latest decision on this issue. And it's not a good one for California employers, because how many California employees do you think go home sick with COVID-19? Or how many California employees do you think go home with COVID-19 potentially being exposed to COVID-19 at work without even having become sick. And that is particularly risky because in those situations, if the employee themselves are not sick, the family may not know to take any precaution, isolate that employee to a bedroom at the far end of the house and make them wear a mask. And I know lots of people whose somebody in the family has gotten COVID and the rest of the family sort of pushes that person down the hall and puts their food outside for them. Some people go through extremes to make sure the rest of the family doesn't get sick. But you don't even know to do that if somebody comes home and supposedly can transmit COVID without becoming ill. So causation is not the sole requirement for the derivative injury rule, according to the court. Looking at the Snyder case, the court said causation is not the sole requirement for application of the derivative injury doctrine, because the doctrine refers to is something much more specific and limiting than what we thought it did before this case. The court really limited derivative injuries to the economic and intangible losses suffered by an employee's loved ones as a result of the employee's disability or death. That's very narrow. And so the stuff that happens outside of the employee's person to some other family member, for example, is not barred by the exclusive remedy rule, according to the court. Separate physical injuries, the result of somebody in the family being disabled or killed, not covered by exclusive remedy. And this limiting definition of the derivative injury rule for physical injuries sustained by non-employees, even when an employee's injury was part of the causal chain leading to that injury, is something new in California. And given the number of COVID cases, even now there's an uptick, a big rise in those cases, and the amount of California employers who could potentially be exposed and the amount of people that they could potentially then in turn expose in that causal chain, to have the court just say, well, none of that matters. That's significant and new in the landscape of California law. So here's what the Court of Appeal, if we have to summarize it as into one slide, this is what the Court of Appeal held. And again, this is the highest final decision on the C's case as we sit here today. They said that take-home COVID contracted by a non-employee third party as a result of contact with an employee is a separate physical injury, and therefore the derivative injury doctrine does not apply. Workers' compensation is not the exclusive remedy, and the non-employee family members and roommates can sue the employer. And by the way, this doesn't just limit it to family members. This could be roommates, live-in, housemates, even potentially guests. Like, if you have family members staying for a few weeks and they become ill because you brought home COVID from work, arguably, then all of a sudden everybody gets to sue that employer, even though those people have never set foot in the employer's place of business. That's what this holding basically says. Now, this is important. The Court of Appeal did not address, this is a bit of like, maybe a little light that at the end of the tunnel, or maybe an escape for C's Candy, but not really, is the fact that the court did not address duty of care. And what duty of care is talking about is that's the actual negligence of C's. So the question that the court did not address, because it wasn't in front of the Court of Appeal at the time, was whether C's Candy owed a duty of care to Mr. Eck, the late Mr. Eck, and the rest of the family. That is a separate question, the court said. And in fact, it was not subject to the appeal that was in front of the court, because remember, the appeal was filed when the trial judge would not dismiss the case right away. So they didn't even get to the duty of care question. They only got to the derivative injury question. The duty of care question really goes to the question of negligence and the duty to protect, how far does the negligence go? So The court doesn't address this. The court doesn't address how far does the duty of care extend beyond an employer's place of business, beyond the scope that we can control things. If we're an employer, that is a question for another day, they said. And one problem with punting that question till later on is that duty of care is something that will really only be addressed by the trial court, maybe on summary judgment motion. Maybe it doesn't even get until it gets to the jury. And for those of you who are familiar with civil litigation, if you can get out of a case on a motion to dismiss based on exclusive remedy rule or some other technical defense, great. You're in and out of that case very quickly, and it doesn't cost the employer very much, relatively speaking. But to get out of a case on summary judgment, so if it's found that the duty of care does in fact warrant summary judgment in favor of the employer, it's a much longer way down the road. A lot of discovery is going to have been completed in the meantime, which costs a lot of money. Expert witnesses have to be paid. Motions for summary judgment have to be filed months later before that issue can be addressed, and that can be very costly to employers. Even if employers could prevail on the duty of care argument, the potential for all of these lawsuits that have to be taken down on summary judgment is still quite expensive for employers, and we don't even know whether the duty of care is, under California law, is narrow enough to protect employers from those lawsuits. So this does create the potential for runaway liability for take-home COVID, this decision. It exposes California employers to lawsuits from individuals and estates, really untold numbers, because we don't know how many, it's basically look at every California employee who goes into a workplace, doesn't work from home. That person potentially could bring that COVID home to family members, who then could potentially sue that employer. Because basically anyone can claim to trace their COVID illness back to an employed family member or roommate, especially in this case, in C's case, because the court said you don't even have to become sick to transmit the disease. So, by the way, the C's Candy attorneys raised all these points to the Court of Appeal. They said, hey, look, you're creating a new rule. If you do this, you're going to create a new rule. It's going to create runaway liability for California employers. And the court said, well, that's not our problem. That's more properly addressed by the legislature than the court. So they said, get the legislature to change the law, but we're not going to do it here in this court. And as anyone knows, getting something past the California legislature is not necessarily easy to do. And, people can debate whether the California legislature always has the best interests of California employers in mind when they pass laws. But that's what the court said in this case. They weren't going to be addressing public policy concerns and runaway liability. So this is when the federal court comes in. So that's where the case stands, right, until the federal court addresses the same issue. Because, by the way, C's Candy appealed from the Court of Appeal up to the California Supreme Court. They filed an appeal and said, whoa, California Supreme Court, you need to jump in on this because this Court of Appeal is creating new law and it's bad law, according, in C's opinion. The California Supreme Court denied review. They simply said, and they don't have to, California Supreme Court doesn't have to take an appeal from the Court of Appeal in every situation. They can just say, no, we don't want to hear it. Just like the US Supreme Court. And they say, no, we don't want to hear it a lot because they get a lot of appeals. So that's what California Supreme Court did in this case. They said, we don't want to hear it. And so that was it, which means that the Court of Appeal decision would become final law on this topic. At least within that Court of Appeal district, and it was probably persuasive authority in every district court in the state of California. Well, yes.
I know one comment we received. Quote, this is intense and extremely concerning for California employees. Just wanted you to know that that's what's being thought out
You know, I'm sorry, your audio was not very good there. Can you say that one more time, and I apologize?
That's okay. One of our attendees indicated that this is this very intense, extremely concerning for California employees.
I agree it's extremely concerning for California employers. It's, I don't know, I don't get, I've been doing workers' comp for so long that nothing really surprises me much anymore, but this was very surprising, and I think for a lot of people. I would also like to point out that I was on the, I was on a panel with of attorneys that got together before this case came down, where we sort of like looked at this and talked about it, and all of us in the room were you know, very concerned that if the court did the wrong thing, it could be very high exposure to California employers, and unfortunately the court did the wrong thing. Okay, so while this is happening, meanwhile, in federal court in San Francisco, the Kusimba versus Victory Woodworks case is filed in federal district trial court in San Francisco. And in that case, the plaintiff in that case was the wife of Robert Kusimba, who was an employee of Victory Woodworks. And his lawsuit, very similar facts to what was alleged in C's. He says he was working for Victory Woodworks, that they knowingly transferred employees who were in a location with an outbreak and to his location, and that he contracted COVID-19. He did, we know that from the lawsuit, and then allegedly brought that COVID-19 home to his family. Fortunately, his wife did not pass away, but she did she did test positive for COVID and was hospitalized for more than a month and kept alive on a respirator. So she had very bad COVID. So he sues, and the family sues on her behalf, Victory Woodworks, saying for using the same arguments that the plaintiffs did in the C's case. So this goes to federal court, but the federal court reaches the opposite result. The federal court in San Francisco dismissed the case and said that the California derivative injury doctrine barred the wife's claims, and that alternatively, Victory Woodworks did not owe her any duty of care because she never came to their facility. She wasn't their employee. She wasn't a guest or customer of Victory Woodworks. She's just somebody who happens to be married to somebody who works there. So they don't owe her a duty of care, and the California derivative injury doctrine bars the claim because the lawsuit is derivative of Robert Kusimba's illness. So it's exactly this very, very similar set of facts, opposite result from the federal court. So this is happening at exactly the same time. So the Kusimbas appealed to the United States Ninth Circuit Court of Appeal. This is the court in California, one step below the United States Supreme Court. The Ninth Circuit Court of Appeal hears the case, and on April 21 of this year, the court said, whoa, we have the Kusimba case, which we agree, it seems like the Ninth Circuit agrees with the federal trial court's conclusion, throwing that case out. But over here, the California Court of Appeal has issued the opposite decision in C's Candies. What gives? So the Ninth Circuit Court of Appeal did something rather extraordinary. It's not unprecedented. It just doesn't happen every day, where the Court of Appeal applied the derivative injury doctrine, or said that it applied, and that there was no duty of care, and that the complaint was properly dismissed. And the Ninth Circuit actually asked the California Supreme Court to weigh in on this. Remember, California Supreme Court already denied C's Candies' appeal, but now the Ninth Circuit is saying, California Supreme Court, we need you to weigh in on this. So what the Ninth Circuit said is that everyone in California, and I think this is the proper, here's this slide right here, just take a picture of this one. This is how this should play out. The Ninth Circuit said everyone in California is responsible not only for the result of his or her own willful acts, but also for an injury occasioned to another by his or her want of ordinary care or skill. Okay, so C's Candy, for example, Victory Woodworks, for example, owes a duty of care not only for somebody who's injured on premises because of your willful or negligent act, but for an injury which essentially comes out of a lack of ordinary care to anybody in California that you injured, okay? But for reasons of public policy, the court said, there are exceptions to this duty of care, this really wide duty of care, and it is limited because of potentially infinite liability, which would follow from every negligent act. And this is, they're relying on a 1992 federal case. So the Court of Appeal, I think, looked at this public policy question and said, there's potentially infinite liability for take-home COVID for every single employee and every single family member and every single roommate. It would be unending. And so that's, the court relied on that, looked at that and said, hey, we got to clamp down. We're going to dismiss this lawsuit because otherwise you're looking at infinite liability to California employers. So in my humble opinion, the correct decision out of the Ninth Circuit Court of Appeal. But the Ninth Circuit Court of Appeal also said, but wait a minute, we can't let this conflict in law go on out there. We can't have one Ninth Circuit court decision applicable to federal cases and one state court decision, Court of Appeal decision applicable to state cases with two different results. So they did this extraordinary thing, which was they asked the California Supreme Court to please take this case, even though you already denied the opportunity to look at it, take this case up and address this question. So these are the questions that the Ninth Circuit put to the California Supreme Court. If an employee contracts COVID in the workplace and brings the virus home to his or her spouse, does California's derivative injury doctrine bar the spouse's claim against the employer? And number two, under California law, does an employer owe a duty to the households of its employees to exercise ordinary care to prevent the spread of COVID-19? Do employers have to police their employees' households in order to control the spread of COVID? Those are basically the questions that the Ninth Circuit asked the California Supreme Court to address. So hot off the presses on June 22nd of this year, a few weeks ago, the California Supreme Court agreed, okay, yes, Ninth Circuit, we will take this case up, granted review, and they will hear the case after originally turning down C's appeal. On July 22nd, just a few days ago, opening briefs were filed in that lawsuit. And that at the bottom is the name of the case that the Supreme Court has designated. So now Supreme Court is not calling this the C's Candy case. They're calling this Kustemba versus Victory Woodworks, and have assigned that case number to it. For those of you who really want to follow this, that is the Supreme Court case. And the reason they're using the Kustemba case rather than C's case is because that's the one the Ninth Circuit basically sent over to them. But it will, if the California Supreme Court were, for example, to rule as the Ninth Circuit did and say this lawsuit, these take-home COVID claims are barred by the derivative injury rule, that would prevail over the Court of Appeal decision. Let's make that clear. So if the California Supreme Court does the right thing, it will be good for California, I think, in my opinion, and California employers most certainly, by clamping down on the potential unlimited take-home COVID lawsuits. So I would be remiss if I didn't mention that meanwhile, while all this is happening literally days ago, in the California legislature, we have AB 1751 is pending. It has passed the Assembly and is pending in the State Senate. This law would extend the California presumption laws for an additional 2 years. Now, why am I mentioning this? Right now on the books, we have the Labor Code sections 3212.86, 87, and 88, which create the safety officer, healthcare worker presumptions, that's 0.87, and the outbreak presumption, that's 0.88. Those presumptions are set to expire at the end of this year. So December 31, 2022 is supposed to be the end of those California presumption laws. This bill would extend that deadline to January 1, 2025. Why is this important? Because the more presumed compensable injuries means the more potential take-home COVID lawsuits, because each one of these presumed compensable injuries that's accepted, that means that, okay, we know that this person has COVID. So a lot of the legal facts that someone would have to prove to establish a take-home COVID lawsuit are established when there's a presumed compensable injury, because they don't even have to ask a jury, oh, did this person get COVID at work? And then they become sick with it, and then they bring it home to their family members, and then the family member get ill. A couple of those questions are answered by if these presumption laws remain on the book, because for certain employees, it's presumed that their injury happened at work, that their COVID happened at work. So we want to keep an eye on that AB 1751, as well as keeping an eye on these important cases. So what do we do? What do we do now? So now we're gonna watch what the legislature and the court are doing on these cases, and we'll obviously keep everybody updated on this. Meanwhile, employers may want to review their workers' comp insurance policies for coverage of take-home COVID. This is something that, usually you get a boilerplate insurance policy, you just, they sign off on it and send it back to the insurer. But now it's worth taking a look because there's a thing called coverage B in workers' comp policies, which may go beyond just plain workers' comp coverage and may apply. And then there's business liability insurance policies separate from workers' comp that may or may not cover the business for these take-home COVID lawsuits. If there is not coverage under workers' comp policies or business insurance policies, then the employer is probably on the hook for that lawsuit without insurance. The other thing we can do is to do everything we can to prevent compensable COVID injuries, obviously, in the first place, and timely deny non-compensable COVID claims. Because again, if we deny it, if it's not a compensable COVID claim, then that sort of cuts off the fact sequence that leads to a take-home COVID lawsuit. How do you prevent COVID injuries in the first place and timely deny non-compensable claims? We have webinars on our, that's for there's another day, but we've already done those webinars and we have them on our website. Any of you are welcome to visit our website where we have on-demand webinars, including talking about COVID-19 presumption laws, how they apply, how to rebut the presumptions, and also strategies for mitigating long-term or long-haul COVID claim risks. So obviously we want to be diligent about every COVID claim that is filed because to the extent it can be denied, it's not only mitigating the risk of workers' comp exposure, it's mitigating the risk of potential take-home COVID lawsuits as well. So every denied COVID claim at the present time really is a twofer because it may limit workers' comp liability and may limit take-home COVID lawsuit liability. So I think we're a little early, which gives us time for questions, but I do want to say thank you for joining us today. And I want to just say a little blurb about us, about RTGR, if I will permit me, that we consider ourselves to be the premier workers' comp defense firm in California. We handle workers' comp defense, 132A, and serious and willful misconduct cases. And as Wendy mentioned in her very kind introduction, we also look at disability and employment matters, especially as they overlap with workers' comp issues.
Tom, we don't have a question, but we did have a comment on the Kusner case. And this person sadly had a father that passed away from asbestos that said the workers had no opportunity to protect themselves and to gear up to keep the asbestos off of them. And so it's a really unfortunate case. And I certainly hope that we are correcting that in today's workplaces.
I think almost certainly we are with asbestos. In fact, my understanding is that for those limited, first of all, asbestos is not nearly as prevalent as it used to be back when that set of facts started, which was some years ago. And secondly, most employers are doing everything who have any kind of exposure or contact with asbestos. The people will don and doff when they get to work. They'll take off their street clothes, put them in a locker, put on hazmat type suits to do the work with the hazardous substance, and then take those things off, which are destroyed with all the particles on them. They'll wear hair nets, they'll have goggles, there's just a whole breathing apparatus, so that there's very limited exposure nowadays for that to happen. But I think that the person's comment is very relevant, because that's why that case came down, that Kessner case, because the Supreme Court of California looked at that set of facts and says, look, the employer had a duty of care, and the workers' comp rules are not the exclusive remedy in a situation where you're exposed, you're getting really toxic asbestos fibers, very toxic stuff, onto your employees' clothing. And then, of course, those employees have to go somewhere at the end of the day, and they're probably going to go home and expose family members who may be even more at risk than the employee themselves, which in fact turned out to be the case in that situation.
Yeah,
So,
well, we are very sorry to hear, Lori, about your loss of your father back in 2011. And we certainly hope that, again, everybody follows the protocols that Tom is laid out here. Wendy, do we have any other questions?
We do have a couple of questions in regards to.
Your mic is breaking up a little.
It might be my internet, and I apologize for that. Here we go. Okay, so here we go, Diane. In regards to SB 863 fee schedule, does the penalty also apply to government entities?
It does. The WCAB and the DIR did not carve out any protections for government agencies.
Okay. The next is there any way to get a little bit more information via email, something that people can share with their coworkers? I know that you'll send something out to anybody who asks. Let's see, if the copy service is not paid within 30 days, can you repeat what that penalty is?
It's 25%, so it's a big chunk of money. And so we want to make sure that we pay those bills. Even if it's 1 day late, they're entitled to that. So please make sure that you pay those bills, or you object to them immediately. And again, like I said, if you object and you pay some portion of it, and it is found that you owe that money, that portion will have the 25% penalty attached to it.
Okay, so Diane, you mentioned earlier that copy services do not have to file liens anymore. Does this mean they no longer have to pay the lien filing fee?
Exactly, that's exactly what it means.
Okay.
So they don't have to file a lien, they don't have to pay the monies, and they can go straight to petition, which then allows them to get in front of the WCAB with that additional cost. Tom, you want to jump in and say anything about petitions and how they work? And
petition for costs are great because there's lots of circumstances. For example, we use a petition for cost when an employee no-shows at a QME exam, and we get a no-show bill from the doctor that we have to then pay in order for the QME to set up another appointment, or even definitely for an AME. So now we're stuck holding this no-show bill. What do we do? How do we get that money back? So we, instead of filing a lien and incurring all of the headaches of filing a lien, we will do a petition for credit or a petition for costs, asking that either we be reimbursed for that fee, or that we get to apply that as a credit against permanent disability, for example. So I think I'm a big fan of petition for costs in those circumstances, and the ones you're also describing.
Okay, so this is when typically the applicant copy service is going to be filing for they would have filed a lien because they weren't receiving payment, and now the courts are allowing them to file a petition for costs, which I think, does that happen faster than a lien?
Yeah, that's the double-edged sword of the petition for costs, is that the other side gets to use it as well. And so there's not a filing fee for a petition for costs. Generally, it's going to vary from board to board and from judge to judge as to what a judge is going to do if they get that petition. I think probably most judges are just going to ignore it until the case in chief is heard. So they're just going to say, well, it's a petition for costs. Nobody's filed a DOR, so I'm not going to bother with this right now. It's just going to sit in the file and we'll deal with it later when, somebody presents me with a CNR or the case is set for trial. Other judges will act on it. They will, do a notice of intention to award the costs potentially, or they'll look and see if there's any opposition to the cost request. I think that the risk of a judge acting on it and doing a notice of intention, or even just ordering the cost to be paid if there's no opposition, is something to consider. So I think that I would do an opposition to a petition for costs if I were the claims administrator. Make sure that this happens in every case, so that at least you're on record as opposing the cost item, and the judge won't just award the cost. They'll know that there's an opposition that they can either deal with now or deal with later on in the case.
Thank you, Tom. Didn't mean to put you on the spot, but you did an excellent job.
We have
Wendy.
a couple other questions. Since the WCAB is allowing in-person trials, what if the parties attending the trial get COVID? Can they file a claim against the WCAB?
That's a great question. Well, I think that those people who are attending the trial as part of their job, so the attorneys, for example, if a claims administrator or employer representative are present at the trial as a witness or as an observer, and they're attending the trial as part of their job, then they potentially have a workers' compensation claim because it was allegedly contracted during work. Attending the trial, if you're a trial lawyer, going to trial is part of your job. So I think those people may have workers' comp claims, which means that potentially there's subrogation liability against the WCAB, although I'm going to guess that there is something that applies. There's some rule that says courts can't, be sued for the damages that happened inside the courtroom absent some gross negligence, but I'm not aware of it, anything such thing on top of my head. So, I mean, potentially, yeah, the WCAB could be liable in those situations. Especially if the WCAB is, there's not exercising protocol, but if everyone is required to mask, and the WCAB is doing everything they can, maybe, but still, it's just like this C's case. You don't want to be in a situation where you're defending that lawsuit because it's very costly, even to win a negligence lawsuit is very, very expensive. And that's the real risk to California employers, is that we get a lot of frivolous claims for take-home COVID that you have to throw money at to make them go away.
Thank you, Tom.
We have quite a few more questions, and I want to just ask a couple more, Tom. So
Okay.
I don't know how quickly we can get through these, but
Well, I have time.
if these cases are found to be a liability, the COVID cases, can you see any potential that providers, medical or government, would come after workers' comp to repay costs?
Come after who for costs?
Let's see. Come back to workers' compensation.
So if the current C's holding applies, I think it really is limited to California employers because they're the ones who get to use the derivative injury doctrine under the Workers' Comp Act. But so if the workers' comp claim is already going on, then those providers, of course, have lien rights within the workers' comp case regarding any injured employees' medical treatment, for example. If these cases, these take-home COVID case lawsuits are allowed to go forward, then yes, those providers, medical providers, should be able to attach liens for the medical treatment that they provide to that injured family member for that take-home COVID. So yeah, there's potential liens in those lawsuits as well from medical providers.
Okay, how is it not defensible that the claimant's husband could not have contracted COVID-19 elsewhere since it's airborne?
That's a great question. And so the court did not address that because they were just looking at the derivative injury doctrine. They said that questions of whether See's Candy owed a duty of care to Mr. Eck, who's not their employee, not their customer, not someone who visited their plant or their facility, do you owe a duty of care to that person who is so remote from your business? We don't know. That's one of the things that the Supreme Court will address because the Ninth Circuit relied on that and asked them to address it. And the other thing we don't know is, so assuming that the case got all the way to the jury, that question from your attendee is exactly what the jury would be looking at. Did Mrs. Eck get her COVID at work? Did Mrs. Eck transmit that COVID to Mr. Eck? Or did Mr. Eck get that COVID somewhere else, right? We don't know because nobody did any discovery in the See's case. It didn't get that far to where people were deposed and other discovery was done to find out if Mr. Eck, was highly exposed to COVID outside of the home and more likely contracted the disease somewhere else. We don't know. But an employer does not want to get to the point of having to do all of that discovery and figure all that out because that's very expensive.
Right.
Yeah. So if the employee declines to file because they receive supplemental CV sick pay, are they barred from claiming independent injury to family?
That's a great question. I would say that the derivative injury rule and the exclusive remedy rule, I know, apply even if the employee does not file a claim. So from other cases, we know that the employee doesn't actually have to file a workers' comp claim. It's just that workers' compensation is the exclusive remedy. So it wouldn't matter if the employee filed the claim or not if the derivative injury rule and the exclusive remedy rule continue to apply as they used to before this See's Candy case, and as I think the Ninth Circuit thinks they do. So it shouldn't matter.
Okay, we often receive rapid positive COVID tests from claimants. Wait, hold on just a second. Somebody just asked an additional question, so I'll pop that. We often receive rapid positive COVID tests from employer, which doesn't indicate claimant's name or anything. My understanding is the law requires PCR tests. Can we deny liability?
Yes, in fact, that's on one of our webinars. On our website rtgrlaw.com. We have a webinar page, and there's a webinar that talks about the COVID defenses, and also we have a blog post on our blog page which specifically addresses the testing requirement of the presumption laws. So the presumption laws require a PCR test or higher accuracy test. Most rapid tests, most rapid antigen or antivirus tests are not as reliable as a PCR. So arguably, those rapid tests that are not as reliable as the PCR, which my understanding is most of them, would not trigger an outbreak. They wouldn't be counted towards an outbreak, and they would not trigger the safety officer or healthcare presumption because each of those presumptions requires an actual PCR test. Now, let me just say this. That just means that the presumption doesn't apply. It doesn't mean that that employee cannot go ahead and still file a workers' comp claim based on a positive rapid test. They don't even need a COVID test to file a workers' comp claim for COVID, right? I mean, they could just say, hey, I got COVID, I think, and I'm filing a claim. How hard is it to file a claim? As we all know, it's really simple. But if there's any chance of them prevailing, they need some sort of evidence that they actually had the disease. So a rapid test would probably be sufficient to at least have the basics for a workers' compensation claim. It just may not be a presumed compensable claim.
Okay, I have a couple questions for Diane, and then I have one last question for you, Tom.
Okay.
So So Diane, do you have something in writing that you can send to folks in regards to the penalty, the 25% increase, et cetera?
Sure, I'd be happy to provide a copy of the actual regs. I can also write up I can write up some bullet points. So anybody that would like something on the regs, some of the changes, some of the highlights, if you would email me at Diane, DIANN, at macropro, macropro.com. I'll be happy to send you guys kind of the highlights of what's going on with the changes in the regulations.
Okay, so there's a question and it reads, is there SOL? And I'm not quite sure of that acronym. The next question, Diane, is so government entities do not have to pay the normal 60 days?
The fee schedule is very clear about it being 30 days, and they do not carve out anything for any agencies. So I don't believe that there is the 60 days of wait allowable, but you'd want to consult with an attorney on that. But the way that the regs are written, it doesn't carve out anything for government agencies.
Okay, is the petition cost from a certain date forward, or let's see, can this be used for old invoices?
The way that the regs are written, it looks like it can be used on older regs, because there are certain in the regs, like the starting date and some other things that have an absolute date. And then when it comes to the petition portion, there isn't a date. So I am imagining we're going to see a lot of petitions for costs on old invoices, especially if they're really old. You know, they're going to try to get their money, and they're going to see if the court will hear that.
Okay, and the last question, Tom, I have for you is, I have a claim that the employee traveled out of state for business and contracted COVID. The claim was then denied as there is no evidence of an outbreak per LC 3212.88. What are your thoughts?
I agree. If there's no outbreak because their specific work site, wasn't first of all, the work site, for the outbreak presumption to apply, there has to be an outbreak at an employer's specific workplace. So traveling out of state and going to, some conference or visiting a client or whatever, that would likely not be an outbreak situation. And then without an outbreak presumption, without a presumption, as I'll say, you can look at our website, you can watch our webinars. Our basic opinion is if there's not a presumption, the claim should probably be denied. If there's not a presumption, the COVID claim should probably be denied, unless there are extraordinary circumstances, because proving that COVID actually was contracted at work as opposed to anywhere else in the world is a very difficult thing for an employee to do. That's why the legislature created the presumptions for police officers and firefighters and hospital workers, and for people who are in a workplace where there is an outbreak. That's why the legislature created those presumptions, because they didn't want those employees, those particular employees, to have to prove that they got their COVID at work. But for everyone else where a presumption doesn't apply, the case should probably be denied. So I agree. And even in presumption cases, we've had our clients deny several presumption cases where, the police officer goes off to Vegas and contracts it at a bachelor party, contracts COVID at the bachelor party, even though the police officer is covered by a presumption. There's contemporaneous non-industrial exposure that explains how he got COVID. And so that claim was denied, for example, and the denial stands. So yes, I agree with that questioner's decision.
Well, we are over time by 10 minutes. This has been a really excellent presentation, and we've got a lot of comments. Wendy?
I just need to have you repeat your email address one last time. Mine is wendy@macropro.com. Diane?
Diane, DIANN @macropro.com, MACROPR.